I'm standing out here in front of 26 Federal Plaza, which is New York City's USCIS offices. In this video, I want to talk about if you are married to a US citizen and they sponsored you for a green card, what are your options if they don't show up for the interview and you still want to get a green card? Hi, my name's Mohammed Salim. I'm an attorney in New York practicing immigration law since 2010. In this video, I'm going to talk about a specific type of law that protects green card applicants who've been married to U.S. citizens and their marriage does not work out because they experience abuse, cruelty, specifically extreme cruelty, how they can still get a green card and not be married to their U.S. husband, wife, citizen, or even their green card holder husband, wife. The law that protects those green card applicants is called Vawa. Under Vawa, people are eligible to get a green card application approved if they can demonstrate that their marriage was in good faith and that they experienced abuse, extreme cruelty, in their marriage. And they don't even have to be married. I'm going to talk about how in this client's situation, her husband didn't show up to the interview today. And that's fine. He didn't need to show up. You know, we're still going to be able to keep her green card application open and alive so that she can have the opportunity to file her WAWA case. And then when that WAWA application gets approved, we'll be able to have her interview for her green card continue, and so that she can still get a green card without being married. Now, a little bit about VAWA. I won't go into detail with it. It stands for VAWA, Violence Against Women Act. It was passed by Congress to protect, and it doesn't have to be for women. It was passed by Congress to protect immigrants who are here in the United States, who have been married to U.S. citizens or green card holders and have experienced abuse at the hands of those citizens. Now, the abuse can be multiple types. It doesn't have to be just physical abuse, meaning battery. It can be extreme cruelty, psychological, emotional, financial. There's different aspects of it. And as an attorney, we work with all of our clients to explore in detail, building a case by demonstrating through whether it's psychological evaluations or through affidavits from friends and family or other testimony and evidence we can get to show that that person did in fact experience abuse at the hands of their U.S. citizen husband, wife, or green card holder husband, wife, and that they should be protected and can get a green card and stay in the United States. There's no risk of those people being deported just because they married somebody in good faith and their husband and wife abused them, and they should suffer by being placed into removal proceedings. This is really important. This protects people, husbands, wives who are in relationships and don't want to be in those relationships because, their partner is abusive, and that, they can still get a green card. There's still hope for them. So they are not trapped in a vulnerable relationship, because as an attorney, I can tell you that there is abuse that takes place. There's a power dynamic in play in immigration law where the U.S. husband, wife, citizen may say, if you don't be a good husband, be a good wife, do what I tell you to do, I'm going to, take away your green card status, or I'm not going to help you with your immigration status, or that you could get deported. I've had many of those clients. I've still been able to protect them by getting them a green card without them being married to their husband or their wife. And this law allows them. And, many people ask me what happens when my husband or wife who filed the petition for me, like this client did, and her husband did file this petition for her, but then refused to show up for the green card interview. What's going to happen to my case? Is it going to be denied? Am I going to end up being placed into removal proceedings? What about all the fees that I paid? So I want to answer those questions. Number one, what you do is that on the day of the interview, you should show up. You should explain to the immigration officer, I would prefer you get a lawyer to go with you, that the case can still be open for the green card, the 485, because you're going to be filing a VAWA application. That's the I-360 application, so that you can continue the case for the green card, and that when the Vawa application gets adjudicated, decided, that you can have the green card interview take place after that. That's important because, number two, you don't want to lose all that money that you pay, which is $1,225. It's a lot of money. The filing fees for the green card application are $1,225. It's very expensive. You don't want to lose all that money just because of the previous I-30 case, was closed or denied. You can still keep that open. The other thing you can do is that you should have a lawyer file a G28 and make sure that the case does continue and go forward. That's important because, it takes up to sometimes 1.5 to 2 years for that VAWA application I-360 to get decided. It'll be a while. So the whole time you want to hold that case for the green card open while your other application and petition gets decided. So this is really important. I hope it helps people. There's a lot of immigrants who are in difficult situations in their marriage, and there might be abuse, but they do have options, and I hope this helps them.